Inveresk plc against Tullis Russell Papermakers Limited.
Dean of Faculty.
Good morning, my Lords. Lords, I appear with Ms. Delbegovich-Broom for the appellants and defenders in the action between Inveresk plc and Tullis Russell Papermakers Limited. Our learned friends, Mr. Curry and Mr. Lake, appear for the respondents. Well, Lords, this is the second of two actions between these parties arising out of the same transaction. The first action is at the instance of the present appellants.
I wonder whether I could interrupt you, Dean of Faculty. I think all of us have struggled with the changes of names, reclaimers, appellants, and so on and so forth. Would it be convenient to describe them as vendor and purchaser? Because then that is essentially the nature of the transaction we're dealing with, isn't it? Well, is it easier to do it that way?
I'm content to do it that way, my Lord, or to call them Tullis, Russell,
yes,
and
Inveresk. Or just Inveresk and Tullis.
Yes. Which might be simpler, as there are two actions.
Right, yes.
And if I might proceed in that way, my Lord.
Very well.
So, as I indicate, my Lord, this is the second of two actions between these parties arising out of the same transaction. The first action is at the instance of Tullis Russell and seeks payment and damages for breach of contract. And as a point of reference, the record in that action is at the Core Bundle Volume 2, tab 25, page 421. I don't go to it at this time, but will come on to look at it.
Yes.
The second action, and it was the second action raised in point of time, is at the instance of Inveresk against Tullis Russell, and is for payment and declarator. And we're only concerned here with the issue of payment. The reclaiming print or record in the action at the instance of Inveresk is at tab 8 of the Core Bundle Volume 2 at page 159. And again, I wouldn't intend to go to it at this time, but will make reference to it in due course. Tullis Russell engage in the manufacture and sale of paper products from their mill at Markinch in Fife, and have done so since 1809. The term paper is perhaps a misnomer. The principal product which Tullis Russell manufacture and supply is what the layman would understand to be or recognise as board or cardboard, which is a product utilised in the printing and packaging industries. Inveresk were at one time competitors of Tullis Russell. Inveresk engaged in the manufacture of similar paper products at 4 paper mills in Scotland. From about 2002, when there was a change in ownership, Inveresk began a policy of closing each of its paper mills and pursuing the development of its mill sites for residential and commercial development. Apart from the perceived value of the mills for development, there was one jewel in the Inveresk crown, and that was the Gemini brand. This was the established brand name of a range of coated board products which Inveresk had manufactured at its Carron Grove mill in Stirlingshire for many years. It had an entrenched customer base in continental Europe, particularly in Germany, Austria, and the Low Countries. Tullis Russell had a very similar manufacturing process to the Carron Grove mill and could produce a product almost identical to the Gemini brand. That was subject to the coating of the product, to which I'll return.
When you say subject to,
there was one process that was different, my lord, which involved coating the board at the end of the manufacturing process. And in the case of Carron Grove Mill, this produced a matte finish. In the case of Tullis Russell, this produced a gloss finish. That didn't have the implications that one might immediately imagine for the use of the product, because if one looks at a board product after it's been printed and sees that it is either glossy or matte, that is not actually a product of the board manufacturer, but of the printing process, which involves the application of lacquers. But the difference in the finish did have a perceived difference in the printability of the product. And there were subjective views that the matte finish was better for printing in some forms and that the gloss finish was better for printing in other forms. But that was essentially the only difference between the products. Notwithstanding the apparent similarities of product, the customer connection of the Gemini brand was so well established that Tullis Russell found it difficult to challenge the market dominance of the Gemini brand in Europe. This was the genesis of the transaction whereby Tullis Russell was to acquire the trademarks and customer connection of the Gemini brand. If I could refer your lordships briefly to the Statement of Facts and Issues, which is in volume 1 of the core bundle, at tab B, paragraph 2, the dispute between the parties arises out of a corporate transaction. The purpose of the transaction was acquisition by Tullis Russell of the Gemini brand of paper, customer information, and the related assets from Inveresk, and the maintenance of the value of the brand by effective transfer of customer connections. If I might also be permitted just to take your lordships for a moment to tab 8, which is the record in the action, which is in the core bundle volume 2, at page 183.
This is the reference to the other action.
No, my lord. This is a reference, first of all, to, well, it is a reference to the pleadings in the other action, that is correct, my lord,
yeah. But
it is again setting up the nature of the transaction between the parties. And these are the answers for Tullis Russell to the claim by Inveresk for additional consideration. And at B, it is averred that if any sums are due by Tullis to Inveresk, they are entitled to retain them pending payment of their claims against Inveresk in terms of the first commercial action. Reference is then made to the pleadings in that action that I'll come to in a moment, The transaction in which the defenders, that is, in which Tullis Russell bought from Inveresk the Gemini brand of paper products and related business and assets, involved two agreements, the asset purchase agreement and the services agreement. That averment is not the subject of admission in these pleadings by Inveresk. However, if I can then take your lordships to tab 25, which is the first action at the instance of Tullis Russell against Inveresk, the document begins at page 421 of the core volume, but if I might take your lordships to Article 2 of Condescendence at page 428. Taking the lettering on the left-hand side, this is 428A, line 3. At or about 9th June 2005, Tullis and Inveresk entered into a transaction recorded in two written agreements, the transaction. And if I may then take your lordships to the position of Inveresk as stated in answer 2 at 429, letter B. Admitted that on or about 9th June 2005, the parties entered into a transaction, the transaction, recorded in two written agreements.
Remaining, I'm sorry. To tell us about the tax implications of there being two agreements.
Very simply put, my lord, Inveresk apparently had tax losses which they could only utilise if they were able to set off against them an income stream as distinct from a capital payment. For that reason, it was proposed and agreed that the transaction should be structured by reference to two separate documents, one which would allow for a capital payment, but one which would represent, or appear to represent, an income stream which could then be utilised by Inveresk in respect of their tax losses. Now,
there was no question of showing only one to the revenue and not the other.
I can't imagine that that would be the case at all, my lord.
They would be bound to see cross-references in the agreements,
Yes.
wouldn't they?
My lord, these documents cannot stand alone. No. It is perfectly clear that one cannot actually fully construe one without reference to the terms of the other. And therefore, both documents would, of course, have been presented, no doubt, to the revenue. But the genesis for the breaking up of the transaction into two documents is accepted to be the apparent or perceived fiscal benefit of having an income stream as well as a capital stream. My lords, remaining at tab 25 and looking again at Inveresk's own averments, this time at page 493, at letter C, Inveresk noticed that Tullis Russell, in their defence to Inveresk's claim for additional consideration, have taken a plea of retention. Tullis have claimed that they are entitled to retain sums due to the present defenders, Inveresk, under the acquisition agreement against illiquid claims under both the services agreement and acquisition agreement. And that's a fair summary of the position as set out here by Inveresk. Tullis have claimed that for the purposes of assessing the availability of a plea of retention, the acquisition agreement and the services agreement form one contract, or alternatively, that there is sufficient reciprocity and mutuality between the obligations in the two agreements for a plea of retention to be available to them. So again, Inveresk clearly understand what the issues are with regard to this matter. And Inveresk go on to say that Inveresk have disputed that a plea of retention is open to Tullis Russell, and they finish by saying Inveresk are entitled to retain sums due by them to Tullis pending settlement of their claims. And indeed, if one goes on to page 518, and I appreciate it may be little more than a jury point, but it's relevant just to see where Inveresk stand. At 518 letter E, Inveresk being entitled to payment from Tullis of additional consideration and sums by way of damages, but they are entitled to retain sums due to Tullis Russell.
So that's a mirror of your plea.
I think one could say it is very much a mirror of our plea. And no doubt it will be elaborated upon and become one of those strange, anomalous animals known as an esto plea. Esto what might be the issue. But there is no doubt that parties are at one to the extent of appreciating that what we're dealing with here is a transaction in which each has regard to mutual or reciprocal obligations that give rise, allegedly, to pleas of retention. If I might move on to the documents which constitute and record the transaction, again, just to notice them first of all, there is the acquisition document, which is at tab 11 in the core bundle volume 1 at page 261. And perhaps if I can just take the Lords at this stage to the recital at page 262. Inveresk is the owner of the owned intellectual property rights, the customer information and the related assets, and has agreed to sell, and Tullis has agreed to purchase the owned intellectual property rights, the customer information and the related assets on the terms and conditions set out in this agreement.
I notice that the definition on page 266 of trademarks refers to the Inveresk brand as well as the Gemini brand. They're related to each other, are they? They're all part of the same thing.
They are essentially, the Inveresk brand was a relatively new brand, and it was almost an afterthought. Inveresk were disposing of their brands because they were shutting down their mills. And in fact, the management and control of Inveresk were not actually exercising executive control over the operation of the paper mills as such. They had executives doing that. And when it became apparent that there was also this Inveresk brand, it was, as it were, added into the equation. But the essential basis for the transaction was the Gemini brand. The Inveresk brand had little, if any, commercial value as a standalone brand. The second contractual document, my Lords, is the services agreement, which is at tab 12. And again, if I could take my Lords to the recitals at page 302, paragraph C in particular, Tullis Russell had requested that Inveresk enter into this agreement for the purposes of ensuring continuity in the manufacture and distribution of the products, and to facilitate the integration of such manufacture and distribution into the existing Tullis Russell operations, and to enable Tullis Russell to obtain the full benefit and value of the assets being acquired under the asset purchase agreement. And of course, the assets largely comprised, apart from the marks, the goodwill of the Gemini brand. And what was critical was the maintenance of that goodwill in the course of a transaction that would involve the transfer of manufacturing from Inveresk at Cadden Grove to Tullis Russell.
It's a problem that arises always when there's an agreement for the sale of assets where there is a time lag between contract and completion.
Indeed. And there could have been a number of solutions. Tullis Russell could have geared up the manufacture in advance of the final settlement. But in fact, for fiscal reasons we've already touched upon, it suited parties to structure the matter in this way. And if we go on to page 303, under definitions, amongst others, owned intellectual property has the meaning in the asset purchase agreement. And that is, in fact, just one of many cross-references. But perhaps of a little more significance is clause 22, which your lordships will find at page 315, under the heading Entire Agreement.
Yes.
This agreement, including the schedule and the asset purchase agreement of even date, contain the whole agreement between the parties in respect to the subject matter of this agreement, and supersede and replace any prior written or oral agreements, representations or understandings between the parties relating to the subject matter.
It's very puzzling because if you turn back to page 278, you find an entire agreement clause in the other contract which doesn't refer to the other document.
Well, in fact, it does, my lord.
Does it?
Because the other document is, in fact, one of those which is referred to in the schedule.
Is that the documents referred to
As
or executed at completion? So you say that by that route you get into the service agreement.
the wording is, I admit, slightly different.
Yes.
But the consequence is the same, because if one actually goes to the documents executed at completion, listed there is the services agreement.
Where do we find that? Is that page 281?
If my lord allows me just a moment, it's at 281, I believe, under the heading Schedule Part 1, and it is number 5.
Yes. Well, at some point, I was trying to do this myself, it would be helpful to have a list of all the cross-references, just so that one understands exactly how
I believe the statement of case does actually include a list, my lord, but I will have that checked, and if it has to be supplemented, that will be done.
Thank you very much.
But at present, Tullis' statement of case does include a list of the cross-references.
Yes.
But in my submission, perhaps one of the most significant is, as I note, the entire agreement clause, because the parties have gone to the trouble of saying the entire agreement, the transaction, is reflected in the acquisition document and the services document. And in my submission, what we actually have is a situation in which the rights and obligations arising under and in terms of the acquisition document and the services document are inextricably linked, which is hardly surprising in my submission, because what one has, as is actually admitted, is one transaction implemented by means of two contractual documents. Now, my lords, two issues have exercised the parties and the court. First, the determination of additional consideration, and second, the matter of retention. And I would intend to deal with each in turn, hopefully with regard to the first, relatively briefly. To put that into context in dealing with additional consideration, if your lordships turn to tab 11, and to the matter of the acquisition of the assets, at page 263, we have the definition of consideration, which is the sum of initial consideration and the additional consideration payable for the assets as set out in this agreement. At page 264, we have the initial consideration, which is a sum of £5 million sterling. And at page 2, we have the definition of additional consideration.
That's back to page 262.
262, my lord.
Yes.
Additional consideration, the sum, if any, payable by Tullis, Russell, in terms of clause 5 and part 5 of the schedule up to a maximum of £2 million. The reference to part 5 is erroneous. It should be to part 3. That is but one of a number of aspects of the drafting that one encounters, which one finds to be less than felicitous.
Well, clause 5 tells you that you look at part 3.
Indeed, sir. Now, before going on to those clauses, could I also refer your lordships to the payment provisions in the services document, which is at tab 12. And if I can ask your lordships to go to page 305, clause 2.1, the parties recognise that the purpose of this agreement is to allow Tullis Russell time to integrate the manufacture and distribution of the products into its existing operations without adversely impacting on the manufacture and supply of the products in the period prior to the completion date, and to protect the value of Tullis Russell's investment in the owned intellectual property rights in terms of the asset purchase agreement. In consideration of the fee identified in clause 3 below, and at the request of Tullis Russell, Inveresk shall, during the life of this agreement, and then a series of matters are set out. Perhaps it's sufficient at this stage just to notice 2.1b. It's to implement an employee incentive scheme to motivate the employees of Inveresk to maximise the sales of the product. C, use all reasonable endeavours to protect the marks, maintain the existing levels of customer service to purchasers and potential purchasers of products, and promote the successful integration of the property rights. At E, to maintain continuity of manufacturing and conduct its business in the ordinary and usual way so as to maintain that business relating to the products as a going concern. And then at 2.2, page 306, Inveresk has agreed to continue to assume the trading risk in respect of the business from the date of this agreement until the completion date. Inveresk shall be entitled to the benefit of the orders received for products due for dispatch prior to the completion date. Now, I just noticed that, my lords, because one has to be very clear about this. Some very substantial payments are made to Inveresk under the services agreement, but that is over and above the receipt in respect of all sales made during the services agreement. So Inveresk have the ongoing benefit of their trade in the products, and in addition are paid a series of fees. And the first of these is found at 3.1. And what it says is, in consideration of Inveresk continuing to manufacture and distribute the products, 2, the undertakings provided by Inveresk to Tullis Russell in respect to the maintenance of the trademark during the life of this agreement, and 3, the use of the trademarks in accordance with the terms of this agreement, that subject to clause 3.4, Tullis Russell shall pay to Inveresk a monthly fee of £1 million on the following dates. And there are then 5 dates. So there's a provision for a payment of £5 million to Inveresk for carrying on the manufacture of the product during the services agreement period, during which time they enjoy the benefit of the sale of the product. And then at clause 15, which your lordships will find at page 312, there are what are termed Inveresk's undertakings in relation to the quota. And, my lords, the quota is the machine that I referred to earlier, which at Carron Grove would carry out the final part of the manufacturing process in respect to the board. Tullis Russell had no wish to acquire the machine, but equally, if they were acquiring the assets, they would not have wished to see a competitor acquire the machine. And that is why we find clause 15.1 and 2 in these terms. 15.1, to enable Inveresk to perform its obligations in clause 2.1 above, Tullis Russell acknowledged that Inveresk will be required to, and Inveresk undertake to, repair and maintain the quota on a fully commissioned basis until the completion date. The laws ask for 5 months. And in return for that, they're paid £600,000 a month for 5 months, making a further payment of £3 million.
Where does that figure come from?
The figure, my lord, is under the quota definition at page 303.
The quota fees, yes, I see.
At the top of the page, under the heading, my lord, quota fees.
Yes. And there's a restriction on disposing of the quota.
Well, then at 15.2, although the service agreement is for 5 months, there's then an obligation on Inveresk for a period of 3 years with regard to the quota machine. And essentially, although they may be retaining the quota machine, they have to ensure that nobody else can operate it for 3 years. While we're at page 312 of the services document, it may be worthwhile just noting clause 16.2d.
Where does it set out that the quota fees are to be paid?
15.3.
It defines them.
Yes, my lord.
15.3.
It's 15.3.
My lord allows me just a moment. If we go down to 15.3,
Oh, yes, I've got it. Yes, thank you.
Tullis Russell
Yep.
shall
Yes, I've
pay the accrued quota fees on the completion date. So it will be, although it accrues at the rate of £600,000 a month, what is actually paid is £3 million.
Yes.
So they're operating a machine they have to operate anyway to manufacture the product for 5 months. And when they sell the product, they're paid for it. But in consideration of them manufacturing the product for 5 months, they get £5 million. And in consideration of them operating the quota machine that they have to operate in order to manufacture the product, they get a further £3 million. And that is perceived to be an income stream.
Clause 16.
Clause 16, my Lord, is perhaps of some interest, inasmuch as it's the only place where goodwill is actually addressed in either the acquisition document or the services document. It's at 16(2), paragraph D. Which provides that Inveresk shall not, at any time after the completion date, do or say anything which is likely or intended to damage the goodwill or reputation of the owned intellectual property rights, or which may lead any person to cease to do business with the purchaser on substantially equivalent terms to those previously offered, or lead any person not to engage in business with the purchaser. So the terms of the services agreement are not just concerned with manufacturing over a 5-month period. They're concerned again with maintaining the value of the asset which has been acquired. The principal part of which is, of course, the customer connection or goodwill associated with the Gemini brand. And one might actually go as far as to say that when one tries to break down the terms of the acquisition document and the terms of the service document, the allocation of responsibilities as between the two is almost random. There are obligations in the services document that you might expect to see in an acquisition document, and there are obligations in the acquisition document that you might expect to see in a services document.
Yes, and perhaps the goodwill is a very good example of that you might well expect to find that in the other agreement, but it happens to be here.
Indeed, so.
Is there anything in the acquisition agreement that could be used to sort of pick this point up, or do you have to go to the services agreement to get the point?
I believe that one can come this close at clause 15(4) of the acquisition agreement, my Lord, at page 278. And it's not quite the point my Lord raises, but it's as close as one comes. Inveresk shall promptly notify Tullis Russell of any claims against Inveresk brought by any third party in respect of any goods manufactured or services provided by Inveresk derived from any of the assets, and Inveresk shall not, without the prior written consent of Tullis Russell, take any steps in relation to such claim which might reasonably be expected to damage the commercial interests of Tullis Russell.
Yes.
So, in my submission, one can reasonably construe that as being to protect the goodwill.
Yes. You would normally see E and F also in a sale of assets agreement.
Indeed, sir. Indeed, sir. And this is why I say the allocation of these responsibilities is almost random as between the two documents. Now, what actually happened here, and I'll come on to develop this just a little in due course, is that Inveresk had essentially ceased to have any interest in the manufacture of board and in the Gemini brand. But along with the obligations under the services agreement, it carried an obligation or liability for any defects in the product they manufactured during that period and before. They encountered a major manufacturing problem. They did not disclose it to Tullis Russell at the time, and they did not disclose it to their customers. The consequence after the end of the services agreement was all too predictable. Where it was anticipated that there might be claims over the ensuing 6 months of a maximum of £200,000, because board is a natural product and It's not exceptional for some defects to manifest themselves. Claims rocketed. Tullis was supposed, under the contract, to be handling those claims. But Inveresk, realizing that they had to pay those claims and appreciating that their cash flow projections had gone completely off the scale, began to intervene. Very aggressively indeed. I mean, it was not challenged that the accusations they leveled against their so-called customers went as far as suggesting dishonesty. The inflation of claims, opportunistic and cynical claims, that's how they were described.
Is this the subject of averment?
It was the subject not only of averment, my lord, but in the initial part of the proof and the cross-action, this evidence wasn't even challenged. The chief executive of Inveresk, who hadn't...
dishonesty on the part of customers.
Indeed, sir. In order to try and deflect these customer claims, Inveresk accused them of being dishonest, cynical and opportunistic, and indeed, as the customers themselves described it, threatened them.
Now, all this is part of the issues in the other action.
It is.
Which has been partly tried, is that right?
Indeed, sir. The consequence was, so Tullis Russell would maintain, a massive blow to the value of the goodwill. And eventually, Tullis Russell had to go to court and interdict Inveresk from making further approaches to customers. They also had to go to court to get an order for Inveresk to disgorge evidence about the manufacturing process that they should have been handing over so that Tullis Russell could try and trace the defective material. The chain was that material manufactured was supplied not only directly to printers, but also to major merchants on the continent. And without details of the manufacture during the services agreement period, Tullis Russell couldn't identify which merchants were holding vast stocks of defective material before they passed it on to printers. And the very real risk there was that once the material went to printers, they began to add value. The printing process, which can involve up to 12 or 14 separate processes, is extremely expensive. If you can identify a problem in the board, you may have lost the value of the board. If you only identify the problem after somebody has printed it and then cut it up to be telephone cards, you have a major problem with consequential loss because of the added value that the printer has put onto the product.
I asked a moment ago whether there was a record of it in the averments, just so that we can see how it's set out. Is it possible to identify where we find that?
I'm going to come on to that, my lord, if I may, and provide detailed cross-references. And it's in the statements of fact. So
yeah.
If I can just give that brief summary at the moment,
yes,
without digressing too far, and say it is a matter of averment, it's also been the subject in the partly heard proof of unchallenged evidence.
Who's hearing the proof, Mr.
I'm sorry, Lord?
Who's hearing the proof?
Lord Drummond-Young is hearing the proof, my lord. And it's due to be completed in May.
May.
A further problem emerged because the chief executive of Inveresk, having been told of defects in product manufactured during the services agreement, wrote to major merchant clients assuring them that it was of merchantable quality. Now again, there shouldn't have been any direct contact between Inveresk and these customers, according to the terms of the agreement, but that is what happened. And that is why Tullis Russell have an action for damages in excess of £5 million.
That's Statement of Facts and Issues, paragraph 2G, I think, gives that detail.
And we then reach the point where Inveresk want to be paid their additional consideration. And that is provided for in tab 11 at page 262, as defined, it is the sum specified in clause 5, which, as my Lord and the Chair noted, then refers us on to the scheduled part 3, which we find at page 292. The Lords, were I not here in the Supreme Court, I might venture that this is a relatively straightforward mechanism for the determination of a figure. The formula is clearly based on the concept of tonnage. And your Lordships will see at clause 1.1 that in the event that the tonnage is less than 15,000 tonnes, the additional consideration will be nil. And thereafter, there is a formula up to a maximum, the maximum figure being £2 million. Tonnage is defined in a somewhat circular manner, but one might notice the definition at the foot of page 292. Tonnage means the amount in tonnes of the product for which Tullis receives orders during the earn-out period and thereafter issues invoices in relation to such tonnage in the invoice period as provided for in the consideration accounts. I would just ask your Lordships to notice that tonnage is defined by reference to the consideration accounts, not the draft consideration accounts. It's the process by which one gets from the draft consideration accounts to the consideration accounts that is then provided for, really quite mechanically, in this Part 3 schedule. At the top of page 293, there's a reference to tonnage audit, which means the external verification of the tonnage by the purchaser's accountants in accordance with paragraph 5 of the schedule. And we'll come on to that in a moment, if I may. But then at clause 4 at page 293, there's a reference to finalisation of draft consideration accounts. So here we have the draft. The purchaser shall prepare and serve on the vendor within 5 business days of 1st November 2006 a draft of the consideration accounts. Draft consideration accounts. Could I just ask your Lordships to notice the earn-out period is defined, runs to 8th November 2006. The invoice period is defined, runs to 22nd November 2006. The tonnage is to be determined by reference to orders during the earn-out period, invoiced during the invoice period, but the draft consideration accounts are to be produced and intimated to Inveresk before the earn-out period has expired.
So you could have an order after the draft accounts were prepared.
Indeed. On the face of it, there's bound to be some adjustment to the original draft consideration accounts because they're prepared before the earn-out period has expired or before the invoice period has expired.
Yes. And even when the 5 business days have gone, you're still within
6th of November.
Yes.
You may have a further 2 days of orders, but more particularly, you may have another 2 weeks of invoicing, my Lord.
So on the face of it, in order to identify the tonnage, you simply look at the invoices, do you?
Essentially, yes. Now, if we go to clause 4.1, we see that the draft consideration accounts have to be served on Inveresk.
Are there any other goods being invoiced, if you like, which are not product?
I can't believe that there would be, my Lord, because
One has to look at the service.
You have to look at the service,
definitions,
yes.
but you have to bear in mind that there was also manufactured product which did not carry the trademark.
That's my point.
And therefore, that material, although invoiced, would not be included within the calculation of tonnage.
We've got some sort of help. It doesn't take us very far at page 317, I think, which is the schedule in the services agreement, which is referred to define products, which I think is what one's supposed to look at.
And it says paper products which have been coated with solid bleach sulfate.
Yes. Just.
But product as defined in the Schedule Part 3, my lord, at 292, means products incorporating the trademarks. So it is the coated board incorporating the trademarks that is to be the calculation of tonnage.
But is that the same coating as the coating referred in Schedule Part 1?
It is, as I understand it, my lord. The coating is the same. The point is that there may be what were termed own label supplies of the same board, because some merchants would have their own trademarks which they would wish to utilise in respect of the onward supply to printers of essentially the same board under a different trademark name. So the goodwill of the Gemini brand attaches to that which is marked as Gemini, but not to that manufactured to the same specification and supplied as own merchant product.
Yeah.
But the Part 1 schedule paperboard products are the products incorporating the trademarks, are they? Or not?
They include the products incorporating the trademarks, my lord.
But that's not quite the same thing.
No.
But do they extend out beyond that?
They
Let's say the schedule, those referred to in Part 1 of the schedule on page 317.
Those referred to in Part 1 of the schedule on 317 include a board carrying the trademark and board supplied as merchant own label.
So if you compare that with what we see at page 292, which is the definition of product, the greater could include the less. The greater would be everything one sees referred to in the schedule, but the lesser element is the part that's actually marked with the Gemini trademark,
Precisely so.
and a balance, the size of which one doesn't know, of own marking
Indeed.
product.
So the additional consideration is not in respect of own marked goods.
Precisely
product.
so. It's in respect of trademarked goods.
So when the draft accounts come to be prepared, they must be prepared only in relation to the, you say, only in relation to the trademark goods.
They should be.
But that'd be a matter for the purchaser to get right, perhaps.
Well, he might want to address that, Lord, and it's an
We
interesting...
thought it would be critical for him to do that, since otherwise he'd be shooting himself in the foot.
So he's got to get the tonnage right, the correct product,
Indeed.
totaled up for the tonnage.
And do the invoices differentiate between
They
the
do.
two?
Because they would know which are merchant-owned brand product and which are not.
And if you look at an invoice, you can tell that, can you?
Apparently so, yes.
So anybody looking at the invoices, who at any rate knows what they're doing,
Someone who knew what they were doing would be able to identify which invoice is related to trademark Gemini branded goods.
so your man who was preparing, or person who was preparing the draft accounts, would be going through that exercise first.
In theory, Lord.
Well, presumably in practice, if he was a competent chap.
Well, if he'd been told the terms of the contract, Lord. But,
By his employer, you mean?
indeed so. It goes further than that, because if I could take my Lord to clause 6 at page 295, it's not just Tullis Russell who are able to monitor the position. What clause 6 provides in part 3 is cooperation and access. Until the tonnage has been agreed or determined, and we'll see the mechanism is agreement or determination by an expert, the vendor and the purchaser shall each, at their own cost, give or procure that the other and the other's accountants, and if relevant, the purchaser's accountants, are given access at all reasonable times to all books and records which are in their respective possession or control, and each party undertakes not to destroy or dispose of those books and records, and B, generally provide to the other's accountants, and if relevant, the purchaser's accountants, such information and assistance as they may reasonably require in relation to the review, agreement, or determination of the draft accounts, the tonnage, and the additional consideration.
Well, that would be very necessary if one's going to work the system through as provided for in clause 4.3, for example, where adjustments can be offered or suggested by by Inveresk.
It also meant that during the period leading up to the date for additional consideration, Inveresk and their accountants had access to all books and records to determine what sales were being made with regard to product and merchant-owned label. So they could be as fully informed of the sales position before the draft consideration accounts came out as were Tullis. And indeed, there was a process by which they regularly sought and were provided with data relating to sales. If I can take my Lord back for a moment to clause 4, which is the finalisation of draft consideration accounts, what we see there is the implementation of what should have been a very strict timetable. And that specific timetable and the time limits it incorporates lead either to agreement, or if that is not achieved within a specified term, determination by an expert. And the determination by the expert should have been completed, in this case, by 17th February 2007.
Just on 4.1, was there an inbuilt problem because of the fact that the earn-out period ended only on the 8th of November, or were 7th and 8th a weekend, so it didn't matter?
I understand that there was a need to revise the figures simply because of that.
Yes,
gap.
well, the letter says that, I think.
In other words, the answer to that question is that there is on the face of the agreement a problem.
There is on the face of the agreement a problem unless Tullis are entitled to adjust the draft consideration account to allow for the expiry of the earn-out period and the invoice period.
And the problem is that they have got to, within the 5th, or would it be the 6th of November, within 5 business days of the 1st of November, produces a date of what, the 6th? But on the 6th, you can't ascertain the tonnage because the tonnage is the tonnage during the earn-out period, which doesn't end till the 8th of November, the tonnage also means issues invoices in relation to such tonnage in the invoice period, which doesn't end till the 22nd of November. That's the problem.
I entirely accept that point. So there was that inherent tension in the structure which would, one perceives, have inevitably
it's a little
resulted.
bit more than a tension, isn't it? It just doesn't work.
Well, it can work, provided that there is a means by which some adjustment can be made to the draft consideration account.
But when Tullis Russell wrote on the 8th of November, they said, in effect, they said these were draft consideration accounts.
And that's all they could be, my lord.
Not just draft, but draft.
Yes. And then they went on in December, after the relevant dates, to adjust them so that they did reflect the earn-out and invoice period specified. And indeed, what the parties did was to novate. They agreed to extend the relevant time periods by a number of days into January in order to accommodate.
And where do we see that agreement? Where do we see that in the documents, the agreement?
When you say, where do we see?
The agreement being made in the documents?
There was no separate written agreement, my Lord.
Just by conduct.
The parties, by
Yes.
conduct between their agents, agreed to extend the time period.
Orally, you mean?
Orally.
Orally.
Is-
Where's the evidence of the oral agreement?
Oh, it's in. It's in the written.
It's in the statement of facts and issues, I think at the top of page 4, little 5.
Roman numeral 5, my Lord.
I mean, it doesn't actually refer to any letter or anything else, but you say that's actings
And
or...
we shall see it
whatever
in
else.
the correspondence of the two parties' solicitors, reflecting their actings with regard to the time limit. And it was extended by agreement to 30th January 2007.
I'm sorry, what was extended by
The
agreement?
time limit by which agreement could be achieved in respect of the draft consideration accounts.
Well, you'll have to help me on that, because I notice in your case, you can say the respondents did notify to the appellants during the review period, this is paragraph 20, that they considered certain adjustments needed to be made. But it wasn't during the review period, was it?
If we come back to the precise dates, it would be 10 days after the 6th of November, it would be 16th November, so it would be the review period as extended by the parties' actings, my Lord, and not the original review period.
But when was it extended by the parties?
During the
I'm at
course...
the moment puzzled as to whether the review period under 4.2, that period was extended, and if so, when?
It was my understanding that it was extended to expire on 30th January 2007.
Well, I'm not sure about that. Forgive me for interrupting, because what appears to have been extended then was the period of 5 days in
Thereafter.
4.4.
I apologise. After the review period expired, there was a further 5-day period within which the parties could either agree the adjustments.
Yeah, well, precisely, but that's not the 4.2 review period.
That is the 4-4 review
It's
period.
the 4.4 period.
And it's that period that was extended to 30th January, my Lord.
Yeah, that's what I was suggesting seems to be the case. But then we're left with a review period of 10 days, which on one view ended on the 18th of November, on another view ended on the 15th of December because of the adjustment. But whichever it is, it wasn't objected to within 10 days.
That is correct.
But if it wasn't objected to within 10 days, why do you not owe the sum either of that in the 8th of November or that of the 15th of December, the 5th of December?
Because the parties then agreed by their actings to extend the period during which adjustment could be considered for the purposes of clause 4.4 to 30th January.
But by what means did they decide it? When was that agreement made and what were its terms? This could be rather important because it might be said, and indeed you might be contending, that the agreement, if we can only discover when it was and what it was, in effect overtook the whole of clause 4 of the schedule.
Well, I don't believe I would seek to go that far, my Lord.
I don't think you can, in view of what's in the Statement of Facts and Issues, because it's agreed that there was no general waiver by either party of the time limits. And that's what appears at the top of page 4. I'm not quite sure how this fits in with what you're being asked about, but it's a qualified statement, isn't it? So you're not in a position to say that the time limits were generally waived by agreement.
And surely it's got to be more than a waiver, hasn't it, in view of clause 20 in the agreement itself? It's got to be an agreement.
Well, it's not a waiver, my Lord. It's essentially the parties novating the terms of their written contract by their mutual conduct.
But what did they agree?
My Lord, If I can take the Lord to the statement of case at page 4.
So is this your
Yes, my Lord, sorry. At Roman numeral 4 and 5, well, in fact, 3, 4 and 5, from the top of page 4, by letter wrongly dated 11th December, but received by the appellant solicitors, that's Tullis Russell solicitors, on 19th January. I'm sorry, my Lord, I said statement of case. It is statement of facts and issues.
Yes.
Yes.
I have misled you.
So where are we in the statement of facts and issues? We're
Page 4, my Lord.
page 4.
At
Yes.
Roman numeral 3 at the top of the page.
Yes.
It should be
The
at
trouble is that
tab
there are
B.
two versions of the statement of facts and issues.
It should be at tab B.
Is there any difference between the two versions of the statement of facts and issues, other than the fact that in probably the second version we have the various footnotes? Otherwise, are the statements
I cannot-
themselves the same?
There certainly shouldn't be, my Lord.
So maybe you'd be kind enough to refer to the paragraph number.
Yes.
It is, my Lord, to be found at paragraph 2H, subparagraph Roman numeral 3.
Yeah.
Yes.
By letter wrongly dated.
So as at that moment, before we get to the letter wrongly dated, has there been any relevant agreement between the parties?
If you look at the letter of the 8th of November, 320, page 327. I mean, Tullis Russell seem at the very bottom of that page to be envisaging final confirmation of tonnage and draft consideration by close of business on the 23rd of November, which is already quite a long way away. Now, do we get anything out of this at all?
The 23rd of November makes sense, doesn't it? Because it it is
just
the
the
day
day
after
after
the end of the invoice period.
Indeed so.
So it makes sense. So somebody, I think, the person who wrote this letter, appreciated that the agreement as it stood raised this problem about having to produce a tonnage figure on the 1st of November, which you couldn't do in accordance with the agreement.
Indeed, it's presumably implicit in the agreement that there will be, that the draft consideration accounts will ultimately, if you like, extend as indicated in the letter of the 8th of November, because it's difficult to see how else the contract could work.
Well, they cannot embrace the earn-out period and the invoice period unless that happens.
Yes.
And that's what's contemplated in the letter my Lord referred to.
Indeed.
On
And that was
the
the
8th of
tension
November.
that I drew attention to in the original definition of the earn-out period and the invoice period when compared with the specified date for the additional consideration draft accounts.
So this is a statement really about the working. It's not a statement of an agreement. It's a statement about how the contract works.
This is how it proceeded, my Lord. And then on 5th December, Tullis intimated their final tonnage figure. And this is what Inveresk referred to as the draft consideration account, although it's not strictly such a thing.
Why not?
Well,
It relates to the period
It was
up
tonnage,
to
it was
the
a tonnage
20th.
figure rather than the draft consideration accounts per se. That's all I mean, Lord.
But it is in essence the input into the draft
Yes.
account, isn't it? Because it does relate to the period up to the 22nd of November, which is what it's supposed to do.
Yes.
The final right-hand column, I think, takes you up to the 22nd.
And there wasn't a great difference in the figures at that stage, was there?
It was a very modest difference.
The original figure is £910,080. What was the revised figure?
The tonnage figure was a little less than 6 tonnes in difference, my Lord. I can't
Yes.
recall the precise figure in monetary terms.
It
but
may
was-
be on that tonnage report, but the bottom line is
It's chopped up. I'm
It's
afraid,
chopped
in my
off,
copy because of the way
unfortunately.
the bundle has been bound up. But certainly the difference in figures was of the order of about 6 tonnes. It was
Well, we can see it in little 1 and little 2, can't we, on that, in paragraph H and on... It's the difference between 20,688 tonnes and 20,683.72 tonnes.
I mean, do you know, if I can just try to get this into my head, the letter of the 8th of November claims to be operating in accordance with paragraph 4.1 of part 3 of the schedule. But am I right in saying that
Sorry, the Lord referred to the letter of...
the 8th of November, page 327. Yes. Because the second paragraph goes, in accordance with paragraph 4.1. Now, just so I get this clear in my mind, that was already 2 days late. Because 4.1 says it should have been prepared and served within 5 business days. Or is it maybe...
5 business days, Lord.
Oh, yes, it might be a
Rather
weekend.
than 5
yes.
days.
Depends when the weekend comes.
So I believe 8th November would have been within the 5 business days of the 1st of November.
Right. Yes.
Right.
So it was on the last day for intimation.
So
And at the second paragraph, you will see that there's a reference to it being based on what it was anticipated would be invoiced on or before 22nd November.
Oh, absolutely. But even that looks as though, therefore, if it's served on the 8th, the 10 days review period should have ended on the 18th. Or is that right, or is that wrong? Or is
on
it
the
business
18th of
days?
November.
Well, it's 10 business days again.
10 business days again, but
So 18 plus 2, is it?
Well,
So 8 plus 10 plus 2, so you would still think it come out about 20th of November, but they're in fact envisaging the 23rd of November.
which is the day after the end of the invoice period. Indeed.
The thing is that some adjustment has to be made to the language because of the problem of the 22nd of November.
The tension is there as soon as you look at the definition of earn-out period and invoice period.
As it stands, it is, yes.
well, it looks from, I don't want to jump ahead too fast, but from page 333, from the narrative in the next letter, that actually the representatives of the parties met and were courteously received and so on in January. So the time frame obviously got extended beyond the 10 working days. And it may be this is part of what you say gives rise to the agreement, simply by actings that the parties were attempting to make this process work by meeting and looking at documents and so on with a view to suggesting adjustments.
There was also a desire to ensure that the accountants of Inveresk could have access to the books and records
Right.
In order that the whole process could be checked by them pursuant to clause 6 of part 3. And that may explain the terms of the letter of 11th December 2006, which was apparently only sent on the 19th of January 2007.
It can't be written.
Really?
It says it was received on the...
It's very odd.
Yes, but it's also written. It refers to the 10th and the 11th of January.
It cannot have been written on the 11th of December, my lord, because it refers to meetings
Yes, exactly.
that took place in January.
Precisely.
So what date do we assume it?
I think it's now accepted that it was sent on the 19th of January
Well, it's
2007.
accepted according to little 3. That's the date on which it is said to have been received.
If you look at the top of page 335, my lord, the date 19th January appears at that point in the
Yes,
letter.
that's true.
Well, it may be it was actually written on the 11th of January. It's a sort of mistake one makes at the beginning of the year.
I apologise if I appear hesitant, my lord, but there's been no dispute until now but that the parties did agree to extend the relevant time limits to 30th January in respect of the 5 business days allowed for in terms of clause 4.4.
Yes.
And I'd understood it to be implicitly accepted that the review period was therefore extended until 5 business days before that date.
Sorry, which date before?
Before 30th January. Now,
30th January.
if my learned friends want to take issue with that, so be it. But certainly, there is no question but that the time limit in terms of 4.4 is 30th January, as agreed by the parties. And that is reflected, if I may say so, in the terms of the statement of facts and issues. At page 4, paragraph 2
I'm sorry, page 4 what?
of the Statement of Facts and Issues,
Perhaps
my
we don't
Lord.
have the paragraph.
It's paragraph little 4.
2H, Roman numeral 4, my Lord.
No, we don't see that date mentioned, I think, in the letter of 19th January. In fact, the letter is very curious because although it starts at page 333 with the date of the 11th of December, when you turn the page over, it has a date at the top of the page, which is 19th of January. So, you can take it, but that is the date.
It can't be the 11th of December anyway, because the very opening sentence of the letter refers to meetings in the 10th and 11th of January.
I think the agreement, as I just heard somebody say, is probably evidence on page 341. Or at any rate presaged by page 341.
Indeed so. I was going to go first of all to the Statement of Facts and Issues at 2H, Roman numeral 4 on page 4, which says the parties then had 5 business days to attempt to agree the respondents' proposed adjustments. That period was extended by agreement to 30th January 2007, and reference is then made to the appendix. But if I take my lords then to the core volume 1, page 341,
Yes.
it's the letter from Inveresk solicitors of 31st January 2007, and it states that the first full paragraph, in response to your letter dated 25 January 2007, requesting an extension to the time allowed for considering Inveresk's proposed adjustments to the tonnage figures, Mr. Harris of these officers spoke with Jenny Nicholson of your firm, explaining that an extension of 5 days was not acceptable to Inveresk, but that they would be prepared to consider an extension to close of business on Tuesday 30th January. We were informed that there was due to be a conference call between yourselves and your clients during Friday afternoon, following which a response to this proposal would be provided. And nothing further was heard on Friday, and when close of business passed yesterday, Tuesday 30th January, without any further communication whatsoever, we assumed that our proposal in respect to the extension had been rejected. We were extremely surprised, therefore, to receive your letter.
That seems to be evidence that there was no agreement, not that there was an agreement.
It goes on, though, my lord. As a result of your lack of communication since Friday and prior to receipt of your letter of yesterday, we've been instructed by Inveresk to invoke the provisions of paragraph 44B and require that a tonnage audit be undertaken. Your letter of 30th January has done nothing to change my client's view in this regard and has in fact reaffirmed their belief that agreement cannot be reached between the parties in respect to the tonnage, and the consideration accounts and a tonnage audit is required. And if I go back again to the Statement of Facts and Issues, the position adopted by both parties at page 4 is that the period under paragraph 4.4 for agreement of adjustments, which was 5 business days after the review period, was extended by agreement to 30th January 2007.
The trouble with that is it's not consistent with the letter you've just read.
I appreciate that, my lord, but I can only proceed on the basis of what the parties have agreed in the Statement of Facts and Issues in that regard.
Well,
how it came about at the end of the day may be more difficult to discern, but that is where the parties
What
end
do
up.
we have to assume, Dean Fair?
Well, I don't ask for any assumption to be made, my lord. It is simply the statement of fact made by the parties at page 4 of the Statement of Facts and Issues, paragraph 2H, subparagraph Roman numeral 4.
Which is?
The parties then had 5 business days to attempt to agree the respondents, that is, Inveresk's proposed adjustments, in terms of paragraph 4.4 of part 3 of the schedule. That period was extended by agreement to 30th January 2007.
Well, one could read what one sees at page 341 as indicating that if the information had come in by that date, then it would have been accepted as within the period. Is that right? That's right?
Although one has
didn't actually
cross-referred to page 341 and to the letter we've already looked at.
trouble with page 341 is that they're asserting there was no agreement, not that there was an agreement.
Lord, I accept that on the face of the document at 341, it's alleged that no final agreement was reached, but the party's position in the statement of facts and issues is that it was reached. And precisely how they arrived there.
It depends on what one's agreeing about. No final agreement was reached on the tonnage.
Absolutely not. It was the question of the adjustments. The matter perhaps becomes a little clearer. I say, hopefully, if one goes to look at the mechanism that runs through 4-2 to 4-4, if I could just look at that for a moment, because it informs one as to what was perhaps in the party's mind at the relevant time. In terms of 4-2, this is at page 293, tab 11, the scheduled part 3. Inveresk may, within 10 business days after service of the draft consideration accounts, that's the review period, A, notify the purchaser, that's Tullis, in writing of any adjustments they consider need to be made to the draft consideration accounts, or B, elect that the purchaser's accountants carry out a tonnage audit in accordance with paragraph 5 of the schedule. So I just noticed, my Lord, that what is envisaged is that there may be no adjustments from Inveresk and the matter may go straight for expert determination at that point in time. That did not happen. And then 4-3, A, if the vendor, that is, if Inveresk notify Tullis during the review period that no adjustment needs to be made to the draft consideration accounts, or Inveresk notify Tullis during the review period that it does not wish to elect that a tonnage audit be undertaken, or if Inveresk does not notify Tullis during the review period of any proposed adjustment to the draft consideration accounts, then the draft consideration accounts tonnage and additional consideration specified in it shall be the consideration accounts tonnage and additional consideration. And then at 4-4, which is where we arrive, if Inveresk notified Tullis during the review period that certain adjustments need to be made, and Tullis and Inveresk agree in writing on the adjustments to be made to the draft consideration accounts and tonnage, they shall jointly incorporate such adjustments into the draft consideration accounts, and the draft consideration accounts are so adjusted, and the tonnage and additional consideration specified in it shall be the consideration accounts and the tonnage for all purposes of this agreement. Or, and this is where we arrive at by the 30th of January, if Inveresk and Tullis are unable to so agree within 5 business days, then paragraph 5 of this part 3 of the schedule shall apply. Now the route...
Well, you say arrive at, and I think I understand what you mean in one sense, but you only arrive there if you've got over the 10-day difficulty in 4-2.
And the position
because if you haven't got over the difficulty in 4-2 and 4-3, you never arrive at 4-4 because within the 10 days there's been no notification by the seller, and since there's been no notification by the seller, the sum in the draft consideration accounts is immediately payable.
But in terms of the parties' actings and what they subsequently agreed, the timetable ran on so that the 5 business days following the intimation of adjustments expired by agreement on 30th of January 2007, and by implication from what is actually said by the parties in the statement of facts and issues, those adjustments were relevant to the determination of the tonnage and were accepted as relevant to the determination of the tonnage, so that they did, in terms of clause 4-4, constitute notification by Inveresk during the review period. Because otherwise, one could not make sense of the parties' agreed position that the 5 business days referred to in 4.4b was by agreement extended to 30th January 2007.
They would also have to have agreed implicitly or expressly that the original review period ran up to the and included the date on which they, well, sorry, start again, must have run up to and included the 19th of January.
Indeed, sir. And that, in my submission, follows implicitly from what is said by the parties in the Statement of Facts and Issues at paragraph 2H, subparagraph 4.
Yes.
That's because in little the 4.2a, the notification contemplated by 4.2a is, subject to the time point, the letter of the 19th of January.
Indeed.
Is that right?
It is.
And your case is that the parties accepted that that was to be treated as in time.
Indeed,
right?
they did. And
So
both
that we
parties-
have that, on that basis at least, you say that's agreed, or at least it's implicit in the agreement at little 4, although it doesn't put it in those terms. You say, is this right? It's implicit in that. So you start on the footing that there has been the vendor has notified the purchaser in writing of the adjustment they wanted. Indeed, they wanted an adjustment to more than the 900,000, to the 1.030 million. And then after that, the contractual procedure did proceed subject to the time point, which you say was agreed.
Indeed.
Is that right?
And there is one further point, if I may make it, my Lord. The 5 business days doesn't run from the expiry of the review period. It runs from the intimation of the adjustments which are accepted as valid adjustments in terms of the contract, which may come at any time within the review period.
Is that looking at 4.4b?
Precisely so.
Is that right? But looking at it, stepping back from the timetable and so on, is the reality of the situation this, that the vendor didn't want to close the matter down in terms of what it would be 4.3. C or D, C rather, because they saw it to their advantage to continue to examine whether the information in their draft was accurate. They
Indeed,
thought
sir.
that they were entitled to more.
Indeed.
And the way to get more was either to agree that there should be an increase in the figures or go to an audit.
Go for an expert determination.
So they were, that's what they were looking for, as one understands it. And your clients were prepared to go along with that to the extent of continuing to negotiate on the figures up to the 30th of January.
And what we see from the letter from Inveresk solicitors is that they only got access with their accountants to check on the 11th of January 2007. If we look at the letter which bears the date 19th December on the first page, but which we know was only sent later.
Yes. Yes. Well, they met on the 10th and the 11th.
Indeed. Now, in fact, Inveresk.
What has in fact happened is it not, that both parties have changed their position 180 degrees. You were keen for a period to maintain your 5th of December tonnage, and then realised that it was, that at least you thought it was completely wrong. So far as the sellers were concerned, they weren't happy with that until they perceived that, in fact, that tonnage figure was dreadfully wrong and should be far less.
And they then wanted to accept it.
And so both parties, for a period, got it, on both cases, both got it terribly wrong.
I wouldn't take issue with that characterisation of the position, my lord. But Inveresk actually proceeded by 2 routes to demand an expert determination. One, they proffered adjustments which the parties agreed they would consider up to 30th January 2007, and by 30th January 2007, the parties had not agreed the adjustments, and therefore you triggered a mechanism that sent you to expert determination. But secondly, and quite separately, they said in terms, we want an expert determination.
Yes, I follow that, but the reason I was asking questions about what the agreement of the parties was this. They do appear, at least on your submission, to have agreed both to an extension of the review period and also to an extension of the 5-day period.
Indeed, sir.
In other words, putting away some quite important parts of the agreement. And it might be said, I'm not saying one moment it could be said, that in effect the parties had departed more or less completely from the system set out in paragraph 4 of the schedule. And in those circumstances, it's a little unreal to try and cling on to a figure which now both parties accept is wrong.
Indeed so, my lord. What I might suggest to my lord, if I may, is that they didn't actually alter the 5 business days period. It remained 5 business days and no more than that. But what they must implicitly have done was extend the review period so that the 5 business days expired on 30th January 2007. That's an alternative.
But which provision gave your clients the right to the audit?
Well, Lord, I can perhaps best explain that.
Well, just tell me which clause you're relying on.
Very simply, my lord, if we go to 44B.
Oh, I see.
Yes, well, that imports
We know that the parties...
paragraph 5, and paragraph 5 is about the vendor notifying that the purchaser notifies the purchaser that it requires a tonnage audit.
But it also says that if the vendor and the purchaser are unable to agree within 5 business days, then paragraph 5 shall apply.
Yes, but paragraph 5 doesn't give your client a right to an audit. It only gives the other side, and that's because the whole scheme of this is you start with the purchaser. The purchaser says the accounts are X. And the vendor then says, well, he looks at X and sees if he's willing to pay X. If he says to receive X, if he thinks he is entitled to more than that, he can say, well, I'm not satisfied with X, I want 2X. And that's what happened here. And then if you can't agree on 2X, or can't agree at all, then the vendor can have a tonnage audit to see whether or not he's entitled to more than X. And that's the whole scheme of the thing. So one of the difficulties, to my mind, is that there's no provision in the contract which gives your client a right to a tonnage audit.
Well, my lord...
We might be able to say, as my Lord Savile was suggesting, you get to a stage where the whole thing's been thrown up into the air and there you are, that sort of thing. But subject to that, it's not easy to see, is it?
And the vendor's right could be waived.
Right.
Well, only if it could be perceived as being purely in the interests of the vendor, which is not an argument that the vendor sought to maintain, certainly in the
He doesn't need to waive it, though. He does. He just say, I'm not notifying the purchaser that I require a tonnage audit. Well, and that's all there is to it. And then you don't ever reach paragraph 5. You've only got yourselves to blame because you're the ones who said that the answer was 900,000.
If we go back to 342, my lord.
Page 342?
Page 342 in the core bundle.
Are you saying that is the notification? That's what they say.
It is precisely that, my lord. It is Inveresk solicitors on 31st January 2007.
Right, okay.
So that you say brings, if you look at 4.4b plus 5.1, you have the situation in which they're entitled to do that, then they do notify. And the question then, you would say, is are they entitled to withdraw from that having got that far?
But they have gone beyond the point of...
I follow that. You say that they did exercise their right under
exactly
paragraph 5.1 at a time when they still thought they were going to be better off when they did it.
Exactly so. So I understand the Lord's point, but in fact we do go beyond that stage.
I see that.
Because Inveresk specifically say, we demand expert determination. The issue might then be, can Inveresk, having demanded expert determination and triggered that mechanism within the contract, say we've decided to revert to the position that you no longer consider to be correct, but which we believe we can hold you to.
You said earlier on that there were two routes. In fact, they really need to. The two routes go together, don't they? I mean,
Well, they come together.
Route one wouldn't be good enough for you because of the point that Lord Clark makes.
Yeah.
So you've got to have Route 2 as well, which is 5.1, the intimation at page 342.
If it was said against me that I could not opt for the expert determination, it was only for Inveresk to opt for it, then I respond by saying that is exactly what they did.
And then we're on to what the auditor can do.
Exactly.
I mean, so the clause for electing is 4.2b, is that right? Is that
The clause
Or is that
that
wrong?
they
Or which did they
refer to
operate?
at 342, my lord,
Sorry, yes, it's what, sorry.
is 44B.
4.4b,
So
sorry.
there are essentially
Oh, that's not.
a number of routes. If I can explain the mechanisms, my lord, if you go to 42B,
Yeah, but they didn't do that
they didn't do that.
because they exercised the
They're right to-
alternative option, namely little a. So you don't ever reach little b
Yes.
because they've
Exactly.
already
So it
exercised their
wasn't
option in
under
little a.
So it's not there.
And they shot themselves in the foot. You shot yourself in the foot originally by getting the numbers all wrong. They then shot themselves in the foot by notifying the purchase within 5.1a. But having done so, the question is what then?
And they get to 51A by virtue of 44B.
Yeah.
Yes.
Yes, quite.
So there's nothing wrong with the letter at pages 341, 342. That is following through the formula and the clause, admittedly out of time, but you say that had been accepted on both sides, that they could do that.
There is a degree of uncertainty, at least in my mind, as to how you get to the 30th of January 2007, but they do get there. And Inveresk then say, in terms of 44B, as we clearly can't agree these adjustments, we elect to go for expert determination in terms of clause 5. And that is what happened.
And then we do come to waiver or what the expert can do. There are two possibilities after that. One is that they're entitled subsequently to say, well, we don't want one after all. And then if that's right, well, that would be all right for them. But if that's wrong, then we're on to what the expert can do or is bound to do or has power to do.
Yes, if I may say, my lord, Inveresk have presented their argument in a variety of different guises.
Well, both sides have all... There's been a lot of ducking and weaving on all sides.
My lord, I'm not seeking to cast a rock in a glass house
Very
at
wise.
all, given my own position. Well, I say my own position, having only appeared once previously in these proceedings, but be that as it may, I think one can endeavour to characterise the position that Inveresk have adopted here. And it has more to do with their assertion that this was not an expert determination at all, but some sort of dispute resolution. And as there ceased to be a dispute, there was nothing to be resolved. And my answer to that is really quite short. This is an expert determination, not a dispute resolution. And I'll come in a moment to some of the case law, but if I can
I couldn't myself work out what the difference between those two things was, because it is at least in part a dispute resolution because of the provision that the decision of the expert would be final. The only question is what it is that the expert is resolving.
Well, what he has to do, it may be one way of putting it. In that context, if I refer your lordships, first of all, to clause 5 at 294, we see the tonnage audit provided for, and the term tonnage audit is defined at the top of 293. It's the external verification of the tonnage.
Yes. Now, at one point you said that we should attach importance to the bottom of the previous page, where tonnage is defined as provided for in the consideration accounts. But to make this work, the word tonnage must have a meaning at the initial stage when one's looking at the draft and is actually working up towards the final accounts, surely.
Indeed, well, we see that in 5.4.
Yes.
If I can come there in a moment. If I can go first of all to 5.2 though.
Yes.
In undertaking the tonnage audit, the accountant shall act as experts and not as arbitrators. So it's quite explicit. And their decision or determination shall be final. And then at 5.4, within 5 business days of receipt by Inveresk of the tonnage audit statement, and that's what has to be prepared by the expert, Inveresk and Tullis shall jointly incorporate in the draft consideration accounts the tonnage as determined by the tonnage audit statements. And, my Lord, that's how we get into the consideration accounts with the tonnage. We're given a tonnage audit statement by the expert. We're then contractually bound to incorporate that into the draft consideration accounts.
Then you've got the payment date, which leads into clause 7 as to when payment must be made. And
Indeed,
so
sir.
If they had not asked for an audit, would you be stuck?
I might be in some difficulty, my Lord.
Is the answer to my question yes, then?
Well, my Lord, that is not the position I'm in, so I would
I understand
submit.
that as well, but I'd be quite interested in the answer.
Well, my Lord, it might be difficult for me to insist upon the requirement, but if we go back to clause 4.4b and consider what would happen if adjustments are intimated and not agreed, and Inveresk then refuse to notify us that they require a tonnage audit. The result is that no payment date will ever arise, and they won't ever be paid additional consideration, presumably.
I'm sorry, I don't. I think you may have said, but I didn't catch it. If the vendor hadn't asked for a tonnage audit, there would be an inability to have agreed under 4.4a, but the review period would have run out, and you have to pay on the basis of the tonnage account.
So back to 4.3.
And also, he would be, the position would be in the vendor's hands, wouldn't it, because of 4.5 little b.
Yes, that's right.
But again, 4.3b is subject to during the review period.
Well, that sort of brings me back to the difficulty as to what the parties agreed with regard to the review period, if anything.
I mean, that's why I'm interested in this qualification to little 5 in the Statement of Facts and Issues, where we're told the parties agreed to some extensions of the timetable, but there was no general waiver by either party of the time limits. And Mr. Curry, no doubt, is going to say, well, there was no general waiver of those time limits, and he's entitled to go back and say, well, because we didn't actually, we tried to make the system work by some kind of informal agreement. It didn't work out, and therefore we're back to the original timetable, and we go back to clause 4.3. I don't know whether that's his argument, but there's a hint of it in that qualification.
The difficulty with going back to 4.3 is that you then have to ignore the express provision during the review period.
Yes, because the original 10 days ran out.
Indeed.
Put another way, if you get as far as 4.4, okay, there can be a disagreement. And if there's a disagreement, the seller only has one option, which is to call for an audit. And if the seller doesn't call for an audit, then it could be said that you are back to the tonnage account.
The Lord refers to the tonnage account, but
No, I mean the consideration account.
had that position arisen, and it didn't, I would submit that if one properly construes clause 4.4b, what it anticipates is that notwithstanding the precise wording of 5.1, if parties haven't reached agreement within reached agreement within 5 business days, then there will be a tonnage audit.
Well, that runs counter to the words in 5.1, doesn't it?
Well, I accept that where it says that the vendor notifies, but one has to read this as a whole, and what's being envisaged is that generally it will be the vendor who notifies that there will be a tonnage audit. But 4.4b is envisaging a situation in which there's no intimation of tonnage audit, but a requirement for a tonnage audit absent agreement between the parties. And 5.1 has to be construed consistently with that.
But there's no suggestion at all that the purchaser ever has a right to a tonnage audit anywhere, is there?
There's no express provision to that effect. But
On the contrary, 4.3b strongly suggests that it's the vendor who has the right to it.
it is the vendor who, under 4.2b, intimates the requirement for an audit. It is the vendor under 4.3b who intimates the requirement for an audit. And there is then a neutral provision under 4.4b saying if you don't have agreement, the provisions in respect of tonnage audit will apply.
But all the way through this, Dean of Faculty, as I read it, all the options, the elections and the option to notify and so on, all rest with the vendor. The purchaser's obligation is to prepare the draft accounts. And the system all depends upon decisions being taken, no doubt, within various time limits by the vendor. And one could approach this on the basis that this is all conceived in the interests of the vendor so that he's properly protected because, of course, initially he doesn't have the information to prepare these draft accounts. Is that not right?
Well,
I mean, they depend on invoices and so on.
Lord, under clause 6, of course, he does have access to all the books and records prior to this point in time.
But the agreement, subject to the date for the draft consideration accounts, works perfectly well if, as the draftsman seems to have contemplated, the buyers were busy defending their consideration account and the sellers were not happy with it.
Indeed.
And if that is what the draftsman was assuming, that the buyers have put forward the consideration account and said, this is what we owe you, and the purchasers and the sellers were saying, no, you owe us more than that, it's perfectly sensible then to give the sellers the option to have an audit to see whether or not that which ex hypothesi the buyers were maintaining was the right figure was correct. The problem has arisen because, I don't wish to put it tendentiously, you want to resile from your consideration accounts.
I'm not sure about the term resile, Lord. During the relevant period, Inveresk had every opportunity to accept them if they wished, and they didn't.
Isn't the whole structure of clauses 4 and 5 based on the simple proposition that the whole purpose of it is to enable the vendor to challenge the purchaser's draft consideration account?
Until we come up to 4.4b, my lord, at that point, if there is no agreement on the adjustments, the draftsman has provided that there will be a tonnage audit.
Yes, he's provided that there will be, that then paragraph 5 will apply, and paragraph 5 gives the vendor the right to ask for a tonnage audit. If he doesn't do that, then he will obviously indicate that he does not want to, because otherwise he'll never be paid anything, as you say. Whereas if he says, I don't want it, then he'll be entitled to be paid. See clause 4.5, little b. And so it does all fit together.
Yeah, and 4.4b really means if the vendor does not agree the purchaser's figures. or the purchaser doesn't agree the vendor's adjustment.
And so, even by that line, we arrive at the point where Inveresk, through their solicitors, say,
Very foolishly asked for one.
we demand an expert determination.
Yeah.
The matter goes over to the expert. And he will determine it in the absence of agreement. And that is what is provided for expressly at page 342 in Inveresk's own solicitor's letter. They didn't just say, we realise we can't agree it. They said, we demand expert determination in the form of a tonnage audit. So however one might construe clause 5.1, its requirements are met.
The question is whether he can waive that subsequently.
That is...
It's a question, anyway.
Well, there are two issues arose. One, an argument by Inveresk that this was a dispute resolution process, not an expert determination. And I see my learned friend shake his head, so we'll go to that in a moment. And secondly, whether they could waive. Now, on the first point, my lord, as to it being a dispute resolution procedure, the shortest way to look at this is to go to Lord Glennie's opinion at tab 6, where he records quite succinctly the position being adopted by Inveresk in respect to this matter. And if we go in the opinion of the Lord Ordinary to page 83, first of all.
Sorry, what page are we looking at? 83.
It's the Lord Ordinary's opinion at tab 6.
Yes, I've got that.
Page 83.
83, thank you very much.
And it is... first of all, paragraph 6. At the foot of the page, Inveresk contend that since they no longer insist on their proposed adjustments to the defender's draft consideration accounts, the result is that the consideration accounts are to be taken as agreed, a tonnage audit is not required, and the figure stated in the defender's draft consideration accounts is binding on the parties. But if we then go on to page 90, paragraph 15, Mr. Lake for Inveresk, turning to the issue of what disputes were to be referred to the expert, Mr. Lake pointed out paragraph 4a showed that the question of the tonnage audit arose in the context of the parties trying to reach agreement on Inveresk's proposed adjustments. If they could not reach agreement, then in terms of 4.4b, the tonnage audit procedure applied. The tonnage audit was to take over when no agreement could be reached on that question. This defined the scope of the tonnage audit. The experts were to consider the draft consideration accounts put forward by the purchasers and the adjustments thereto suggested by the vendors, and to look at those in the light of all relevant material to determine whether the proposed adjustments needed to be made. That was all that was required to determine. Support for this was to be found in terms of paragraph 5.2, which provided that the decision of the purchaser's accountants acting as experts was binding as to any matter referred to them for determination. Since their only role as experts was to carry out the tonnage audit, this provision pointed clearly to the intention that they were to determine specific matters of difference between the parties arising out of the draft consideration accounts and the proposed adjustments thereto. This was a dispute resolution procedure, and the scope of the dispute was identified by the disagreement of the parties in these two documents. And then Mr. Lake submitted that the relevant question was, what had the parties agreed to remit to the expert? And his answer was that they had agreed to remit only the question of whether the proposed adjustments should be made to the draft consideration accounts served in accordance with paragraph 4.1. So the whole force of their argument was to the effect that all that they had actually referred for expert determination was whether or not the proposed adjustments to the draft consideration accounts should or should not be applied to the draft consideration accounts. And that was something that they said they could then waive because they were their adjustments. And his lordship accepted that argument, because if your lordships go on to page 99, what he said was at the foot of the page, last 5 lines, the words as to any matter referred to them for determination point very strongly to an understanding that the tonnage audit is not a general assessment of tonnage in the round, but is constrained by the positions adopted by the parties in the draft consideration accounts and the proposed adjustments, if any. And this is what led on to what, in my respectful submission, was an entirely sterile argument as to whether or not Tullis Russell had any implied power to alter the draft consideration accounts. But the position clearly adopted by Inveresk was that the only issue under clause 5 was a dispute resolution with respect to the adjustments which they had proposed and which had not been agreed. That was their line of argument.
And what was the submission he rejected?
The submission he rejected was that once an expert determination was triggered, an expert determination should take place in the absence of the parties having agreed. The point being this, my lord, that part 3 of the schedule envisaged one of 3 events that could transform the draft consideration accounts into the consideration accounts. The first was that the draft consideration accounts would simply be accepted. And then under 4.3, they become the consideration accounts. The second would be that adjustments are proposed and the adjusted draft consideration accounts, as agreed, become the consideration accounts. That's under 4.4.
If I understand your submission correctly, if you look at clause 5, what the auditor does is to audit the tonnage, which is defined in the definition section, and to confirm and verify the tonnage. And I imagine you would say, well, it can't be to confirm and verify the agreement, firstly because it doesn't say so, and secondly, I'm not quite sure how you could confirm or verify an agreement where there is disagreement.
Absolutely. And it goes further. We'll see in the respondent's note of argument how they talk about a check. The whole point is that the expert is to make his own determination. He might decide that the draft consideration accounts are totally erroneous. He might decide that the adjustments are totally erroneous. He's not bound either by the draft consideration accounts or the proposed adjustments.
So your the first possibility, just going back to your 3 possibilities, the first possibility was that the draft accounts are accepted, and if they're accepted, that's the end of it.
Indeed.
So you have the purchaser's proposals. The second is that an adjustment is proposed, presumably an adjustment upwards by the vendor, and that's accepted, in which case the adjusted upwards figure is then payable. And your third is then what?
Expert determination, the product of which is what is termed a tonnage audit statement.
And then once you get to that stage, it's a free-for-all.
And then you go to 5.4.
And that gives you your timetable
And
for payment.
at 5.4, it expressly provides that once you've got the tonnage audit statement, both parties are bound to incorporate it into the draft consideration accounts, and they shall then date those consideration accounts and the calculation of tonnage, and that will become the payment date.
Yes.
It's an external verification
Absolutely.
of the tonnage.
So if you go back to
on the
page...
outside determining what the tonnage of
Yes.
the product
It's
was.
defined as an external verification.
So page 99, Lord Glennie's sentence at the bottom of page 99, you say is misconceived.
Indeed, but he was led there by Inveresk
Yes,
submission.
yes. Well, we've reached 1 o'clock, Dean of Faculty. Would that be a convenient point at which to stop?
It would be.
And we look forward to seeing you at 2 o'clock.